You know, the old saying, if you don't like the weather in Idaho, just wait 15 minutes. It'll change. Well, lately, the weather has been more predictable, a bit more predictable, and a bit more stable than what's been happening with Idaho's near-total abortion ban. Don't like a recent ruling on its legality? Just wait. It'll change. This week, a new ruling on an old ruling that overturned another ruling, which makes perfect sense, right? Well, Joe Paris swears he has it all figured out for us and joins us now to clear up where this law stands today. Joe?
Well, Brian, we're talking about a specific section of Idaho's total abortion ban that concerns EMTALA, the Emergency Medical Treatment and Labor Act. And the Biden White House was and is focused on the Idaho law and the portion we're going to talk about specifically. So, last summer, August of 2022, the United States Department of Justice, they sued Idaho in federal court, arguing that the state's near-total abortion ban violates EMTALA. So that federal provision requires hospitals to provide stabilizing treatment in emergency situations. The question at hand, does that include an abortion deemed necessary to prevent the death or serious impairment of the mother? An Idaho judge originally agreed with the Justice Department and blocked the abortion ban from being enforced in emergency medical situations. However, a three-judge panel from the Ninth Circuit Court of Appeals, they overturned that decision on September 29th, allowing the abortion law to fully take effect. But in October, weeks later, that changed again. The Ninth Circuit temporarily blocked that law from being enforced in emergency medical situations and granted a request for a rehearing before a full judicial panel. So, as you would have guessed, the Idaho legislature quickly issued a motion to stay or stop the injunction while the appeal process continues. And this week, we learned that the Idaho legislature's request is denied. But there will soon be more movement. The Ninth Circuit Court of Appeals ruled that they will continue to review the injunction and questions around EMTALA and Idaho law. Oral arguments are now set for the week of January 22nd, so early next year, in Pasadena, California. And the Ninth Circuit has elevated this case to being heard en banc. And this means that a panel of judges, not just one, are studying the case. And the Ninth Circuit, which again Idaho falls into here in the West, has a unique system compared to other circuits. An en banc panel in the Ninth Circuit consists of 11 randomly selected judges. And the chief judge of the circuit presides over the hearing. And there are 29 in the circuit in total. And the Ninth Circuit Court of Appeals, they operate a little bit differently than other circuits. So most circuits, they'll hold the en banc hearings with all their judges in their Court of Appeals. But because of the large roster of judges in the Ninth Circuit, en banc hearings are held with only 11. And you may wonder, okay, well, where do those judges come from? Well, those 11 judges are actually a mix of judges that have been appointed by presidents, President Clinton, Bush, Obama, Trump, and some from President Biden recently. And I can tell you, Idaho Republicans are historically not a major fan of the Ninth Circuit Court of Appeals because of the amount of liberal judges on the circuit. And California, Washington, Oregon is a big part of that. So the group will decide, though, the implications of Idaho law and EMTALA. And if it is appealed, Brian, eventually the next step for all of this would be the United States Supreme Court. Some believe, and some have said since last year, that they believe this case will go the distance to the Supreme Court. We will see.
If not this one, then I'm sure another one will. Another case of snip snap coming your way. All right, thanks, Joe.